My lord, I beg to mention item number 4. Maybe listed tomorrow. Since the senior counsel is coming from Guwahati.
Tomorrow?
Yeah, tomorrow on 24. We have taken a consent also from there.
Item 4.
Yeah.
It's for orders only.
It's for orders.
We'll see.
We'll just wait. It's for orders. Just wait for witness.
My lord, senior counsel is coming
No,
from
we'll
Guwahati.
see it in orders what is to be done today. We'll see. Wait for your turn.
Wait for your turn, please.
Wait for some time. We'll take up. We'll see. List this matter before any appropriate bench put on one of us. We didn't recommend.
Yes.
Your Lordship, we need some time to file our affidavit, Your Lordship. 2
Huh?
weeks affidavit, Your Lordship. 2 weeks. maybe.
Affidavit?
Yes.
Or Mr. So and so, learned counsel for the petitioner, and also Mr. MS Arbasar, learned state counsel, praise for and granted 2 weeks.
2 weeks, Your
2
Lordship.
weeks time. 2 weeks time. Praise the Lord. List after 2 weeks, so as to enable the learned state counsel to file their counter affidavit.
Lordship. Okay.
What to be that?
My lord,
They have not argued.
I would just like to apprise that one writ petition. Item number 2 in the court number 1 is connected to this.
Doesn't matter. We're sitting in division by day. We'll see when there is a single bench. You are supposed to file affidavit.
Yes.
Order number 3 and 5, 5 were supposed to file the affidavit.
Hmm?
On 3 and 5, they were supposed to file the affidavit.
Yes.
On the basis of that, last time also they have sought time from this honorable
Now,
court.
what is the difficulty, Mr. Tara?
I don't have difficulty.
Then you comply. If you don't have any difficulty,
Just I place some records.
what records?
Other day.
Your affidavit says,
No, my lord.
no, your affidavit says,
Yeah.
you have filed the affidavit.
I have filed the affidavit, but.
It says that there is a dispute about regarding ownership.
Yes.
Who will settle that?
My lord,
You have already, occupied the land. You have used it, put to use it. Isn't it?
yes, my lord, that paragraph 3 of the
And
order.
simply
passed
you have
the writ
referred,
appeal.
it to the Secretary Land
My
Management.
lord, my lord,
What is the procedure? We would like to know.
my lord, just give me 1 minute so that I can explain the things in a proper perspective. No, my lord, what had happened was after filing of this affidavit by the deputy commissioner, then other day the matter was listed, my lord. Then few reservations in a very serious nature held on from their lordships. So then I was asked to advise the client as to how the sacrosanct order of this honorable court can be executed, my lord. Now thereafter, since I have assured this honorable court that I would be advising my client, my lord. So accordingly, my lord, I followed all the records along with my client, my lord. Then on examination, my lord, I said, keep prima facie, if you don't comply with the directive of this honorable court, you will be in trouble. Then my client asked me, what is your legal acumen to resolve this issue, my lord? Then I started perusing all the records, my lord. Then finally, my lord, that last order in my affidavit was, I told him to recall it. The order has been recalled, my lord. Now assessment has already been done. In view of the paragraph 3 of the order passed in the read appeal and the paragraph 4 of the single judge. Pursuant thereto, my lord, on 28th, my lord, when I had a conference with my client, then this has come out, my lord. Just I place it for a moment. Now the situation as it stands, my lord, 31 crore amount is to be deposited by the civil aviation. Now, without fund being provided to me, my lord, I cannot disburse the compensation. That is my stand, my lord.
It's a government of Arunachal Pradesh department.
Yes. The department
So
of,
you have placed these matters before civilization. She is there. So why is the money not being released?
Because of that order which my friend has just taken the investment report.
Recall,
No, we have moved our file for sanction.
sanction.
Look, I have filed a affidavit also, my reply also this morning.
Well, in that case, we'll give you 2 months' time to comply.
Comply.
That's all. Nothing will.
Mr.
Right.
Tara,
First side may be allowed to change the officer who had lost transferred in 2017 has been made a party in Director of Civil Aviation. Thank you.
Who is the
I have taken
present incumbent?
the present incumbent is already I have filed, but then it was because of the press.
but he is not a
I
party.
get to file,
He is not a party. The present incumbent is not a party.
not a party.
You implead him
Post that may be changed.
Huh?
Post that.
So will not change, let him file
Let
it.
them file it.
Yes.
But Mr.
Can be
Tara,
heard, otherwise.
Madam.
What's it?
Tara and Mr.
my lord,
One thing we must not lose sight here. As a contempt court, we can't go behind the order. We'll have to only see whether the order is complied or not. So at a particular point of time, it is not being complied, then the powers have to be exercised. So this matter, let it not go to that extent. Before that, settle it out. You have not filed any review, you have not filed any appeal against that. You have accepted that order. So comply.
My lord, on 28th, I have a difficulty, lordship. If the matter can be fixed on 29.
Let there be a compliance, let the money be transferred, then we will.
as a court officer, we are.
You are not you need not take
duty
it,
on-
you need not take it on you. You impress
No,
upon your
my lord,
client.
Only what has fallen from my lord, may I just clarify in a nutshell, my lord? I am a deputy commissioner. As an individual, I have been brought in here as a contemner. But my lord, as an individual Talaputong,
The procedure requires,
I cannot.
procedure requires that this should be in person.
Your office has to pursue
It's
the
okay.
matter. Your office has
My
to
lord,
pursue.
we have written a series of reminders also.
Okay, okay.
Atul,
I
just-
think ultimately,
It's you, through who you, the payment will come. That's what we
They let them deposit money, I am just.
Yes,
disbursing.
yes.
That-
you brought,
There is
brought,
any-
brought this by way of affidavit.
Yeah, I will bring it on.
Bring it,
On record.
sorry, bring it on record.
Well, instead of
take notice of all this.
29, you know, instead of.
29,
28, your lordship, because that was my instruction from my senior, so
28.
28.
You file your affidavit on
Otherwise-
the IA for implement of the
The
present
new-
income.
Your Honor, it is your lordship, because 28, why I'm saying is because we have this contention because the name has not to be changed. That's why. So the respondent number 1,
The name which the respondent have been
See, you
seeking.
should also remember,
Yes, your lord.
it is only your duty to brought before the court.
Yes, your lord.
It's between the contender and the court.
That is there.
You don't insist on it.
That's why we are praying that if this can be heard on 28th.
You know, let them find on let
No, whatever they want to do, we'll list it tomorrow on 28th.
Yes,
And we'll
Your
pass
Lordship.
appropriate
Thereafter,
order
if
if they
they seek
doesn't take
time-
any steps.
Yes.
You want ultimately the compliance of the.
Yes, Your
You want the
Lord.
punishment or the compliance?
No, their intention is to get the compliance only. Punishment to officer already. What-
It's okay, it's okay. We want, you have brought it before us and we'll look into it. And only procedural technical aspect, when there's a new incumbent,
Yes, sir.
you bring him, you implead him
That aspect.
or her.
It's
That's all.
for your betterment, my lord is
Yes,
saying
I
that.
agree with that, your lordship.
We file IA.
Okay, next.
Including the new.
My lord,
28, 28.
I am seeking for 29.
She is seeking for 28.
Well, 1 day. because
1 day only.
we have-
Okay, okay, 29, 29.
Grateful.
Sir, here, the respondent number 4 is what to be served. No point in.
In item 4, my lord, we have already filed our affidavit.
You are entering appearance. Item number, no, respond number 4.
Respondent,
Office note.
Office note dated 22/11.
government has filed.
Mr. Kaku,
Yes,
K. Potham, learned counsel for the petitioner,
yes.
appellant, and Mr. N. Ratan, for additional learned senior learned additional advocate general for the state. Office note dated 22/11/23 reflects that service upon respondent number 4. Service report in respect of respondent number 4 is still awaited. List after 4 weeks.
4 weeks.
Published.
4 weeks.
Maybe. Lordship, if my brain is ready, it can be disposed of today, Lordship. It can be, matter can be disposed of today.
IA, what is IA?
I
has
is
been
for
disposed of.
stay of the.
Okay, you have already, not in the IA, in the main you have.
In the
listed.
main,
There's the interim one.
because interim is already there, Lordship. Yeah, Lordship, the petitioner was working as a driver in the Informations and Public Relations Department, Government of Arunachal Pradesh, Lordship. In the capacity of driver, Lordship. In the year 1996, Lordship, he went for, Lordship, on leave of 65 days, Lordship. After completions of 65, he never came back, Lordship. He never attended. Then notice was served to him, and then thereafter termination notice, termination order was issued in year 1998. Lordship. Thereafter, he is silent for 18 years, Lordship. In year 2016, he filed one representation, Lordship, for the first time from 98. Then followed by one read petition before the Sonora Court, Lordship. Then that read petition was disposed of, directing the state authority to consider his representation, Lordship. Accordingly, representation was considered and it was rejected, Lordship. Thereafter, Lordship, he filed the second read petition, Lordship, wherein the present impugn order has been passed, Lordship. By way of considerations in terms of the past order, the order which has been passed by the authority that has not been challenged in the second read petition, Lordship. More or less, Lordship, with same contention, the second read petition was filed, Lordship. Then I'm taking, Lordship, to the impugn order, Lordship. Kindly come to page, Lordship, 14, annexure 1, Lordship.
1/4.
14, Lordship, annexure 1.
Before that, just type page 53 for a minute, I'll be clear. This repetition was filed in 2020. 53, page 53.
It starts from page 14.
Just,
Just,
just.
53. This is the correct. The 98 order he wants it is. Then he should come to page 78. This is the first time he approached this court. 78.
Yes. You have quoted the wrong provisions
Lordship,
or you have misinterpreted.
Lordship, as per learned single bench observation, Lordship. Since we have quoted invoked the wrong provision,
Wrong
that's a
provision.
temporary service, Lordship.
So what is the right provision?
The
Same provision.
CCS rules, that should be in CCS rules,
So
Lordship.
it's the same provision.
Not the same provision, Lordship.
Let us see what you have quoted and what you have
But
you should have invoked.
Invoke, Lordship, here,
Learned Single Judge has said
yes, Lordship.
since it doesn't let us see.
Therefore, I am taking Lordship to the order, impugn order is the page 14 and relevant
Yes.
is paragraph 7 onwards, Lordship.
Rule 2.
Paragraph 7, page 18, Lordship.
Huh?
Page 18,
Yes.
paragraph 7, Lordship. This is
Yes.
the observations, the relevant portions of the impugn judgment.
Yes, just read it. Read it.
A reading of title of CCS TS rules as well as the purpose for which the rules have been framed. It appears that the rules would be applicable to the temporary government servants who are in temporary service. To be in temporary service, the conditions precedent required to be satisfied that the persons concerned must be in a temporary post or officiating in a permanent post. In the present case, going by the order that is so and so, by which the petitioner was appointed, the conditions precedents are not satisfied. The petitioner was neither appointed against a temporary post, nor he was appointed as officiating in a permanent post. As the impugn terminated notice has been made under Rule 5.1 of the CCS TS rules, and as the rules itself would be not applicable in case of the petitioner. Therefore, the impugn order of termination could not have been issued under Rule so and so. This is the one of the second Lordship. We have taken note of the commission's letter so and so, which gives an indication that even the records are not clear as to whether the notice of termination was served upon the petitioner, and also that the notice was not published in official gazette or in any local newspaper. From such point of view also, the terminations of the service notice that is so and so requires interference. Even if otherwise the termination notice would have been acceptable in law, but as because it was not served upon the petitioner, it would not have any effect under the law, and nor it would be binding on him. The law in this respect has been considered by the Honorable Supreme Court in the case of state of so and so and so and so, wherein in paragraph 16 it has been provided that an order passed but written in file without being communicated to the plaintiff can have no force or authority whatsoever, and the same has no valid existence in the eye of law, or claim to have come into operations and effect. No reliance can be placed on the same to even assert a claim based on its content. It is stated that the petitioner had retired from service on 31st March 2019, and accordingly, upon interference of the order of termination, it will have to be construed that the petitioner would have been in service up to the date of his retirement on 31st March 2019. Accordingly, as a consequence of the interference of the notice of termination upon the petitioner, the respondents are directed to provide the petitioner with necessary pensionary benefit as admissible under the rules. We are of the view that the Director of Information and Public Relations, Government of Arunachal Pradesh, Nahalagan, had invoked a wrong power or authority to terminate the service of the petitioner, which under the rules would not have been applicable. If there are reasons to terminate the petitioner, perhaps it was for the Director of Information and Public Relations, Government of Arunachal Pradesh, Nahalagan, to invoke such rules, which would have been applicable for terminations of an employee, but it was not done in the present case. Accordingly, the termination notice that is so and so is set aside. But having taken note of the aspect that writ petition was filed in the year 2020, whereas it is a termination notice of year 1998, although we are inclined to hold the writ petition to be maintainable for the reason that medical documents are placed on record, showing that the petitioner was not in an appropriate condition to have approached this court earlier. But at the same time, we are not inclined to provide for any back wages to the petitioner from the year 1998 lawsuit. Here, lawsuit, the first is the invoking of the wrong provision. This is one of the ground lawsuit. Secondly, lawsuit. Second is the termination notice was not served. That's the termination order was not served to the petitioner lawsuit. That's the second reason. And third reason is a delay. Lana single bench has said delay has been condoned by supporting with supporting of medical documents lawsuit. Now I'm taking lawsuit to the medical certificate lawsuit.
Why you are going back? Last two first. You come to the first.
So for pass is concerned, lawsuit. Pass is concerned is more or less it's I think it's admitted position that lawsuit. We have invoked the wrong provision lawsuit.
What is the right provision?
It should
What is
have,
the appropriate provision?
to me, lawsuit, it should have been lawsuit, CSS rules lawsuit.
This is what rules?
This is a temporary service rules lawsuit.
Okay.
The claim of the petitioner is that he was not a lawsuit temporary employee. So therefore, temporary
According
service.
to you agreed to the funding of the learner single judge.
Lawsuit, to that aspect, lawsuit, it seems lawsuit to me also.
So forget that ground then.
Yes,
If you,
I'm not on that also lawsuit. So for my appeal is
and second
concerned
is service regarding service of termination.
termination lawsuit. Second is second is concern lawsuit. May I take lawsuit to the
That give that CCS TS rules. Let's move one by one. Correct?
With regard to the service of notice.
I'm coming to that. I'm coming to that lawsuit. The firstly lawsuit, it is not the pleaded case of the petitioner that the termination order was not served to the petitioner lawsuit. That is not the pleaded case lawsuit in the writ petition lawsuit. And apart from that lawsuit, if lawsuit see the order dated 6 March to the
You have a copy of the temporary service rules. CCS temporary service.
It's there. It's the 773.
I'll tell you, I'm just giving.
773. Page 773. Page 773. Is it so?
Yes.
Is it?
yes.
This is what it is.
Hmm? He was confirm or a regular employee?
Lordship, so far his nature of his service is concerned, Lordship.
Regular.
We are just assuming, Lordship, because his service book is missing from the office, Lordship.
Who to blame?
That part, therefore, I'm not pressing on that, Lordship. I'm not pressing on that, Lordship.
So anyway, you agree to that, it's not applicable.
Lord, because here, Lordship, the definitions of temporary service has
Ah.
been given under section 2.
So
Lordship.
learned single judge was correct, is correct.
So far, that part, Lordship.
Then, second.
Then second is concerned, so far this termination order was served to the petitioner or not. Firstly, Lordship, that was not the pleaded case, Lordship.
Forget it.
Not the pleaded case,
You first heard, we'll come to that.
Lordship.
You first established that whether it was served or not.
Yes, I'm Lordship. Here, Lordship, kindly come to page 81, Lordship.
81.
Firstly, it was not pleaded case. That needs to be noted, Lordship. That needs to be noted, Lordship. I'll in support of that, I'm coming,
In
Lordship.
that case, we may not go to the whether it was served or not. If you say that, what is the learned single judge finding? First, you have invoked the wrong provision, or which ought not to have been.
Lordship,
Second-
that so far it was served or not, that issue has been decided, Lordship, without there being issue, Lordship, in the read petition, Lordship. We were not given the opportunity to, Lordship, reply on that issue.
Page 81.
81, Lordship.
Hmm.
If you can come back to page 18.
Page 80, Lordship. Yes, Lordship.
It starts from page 78, the earlier order.
Lordship.
And here the only plea was subject to correction from the order, what can be put, that my salaries are not being paid. He had not contended before the court that his services were terminated in the earlier notification. It was only with your order at page 81. Is that the case that he came to know that he was terminated? And what prevented him in 1988 when he was not joining to invoke the provisions of the Department Proceedings, initiate unauthorized absence, a charge of unauthorized absence against him under the CCSS rules?
Lordship, because it was already terminated in year 1998, Lordship.
How can you terminate without a proceeding? Why was that proceeding waived? Or were there a proceeding initiated?
Lordship. So, Lordship, that Lordship,
Because you don't even say that in your order. There is no reflection given,
Lordship.
page 81.
Page 81. Page 81.
Lordship, page 81.
What do you want to say?
Lordship, so far this read petitions 31 of 2018 is concerned, Lordship, which Lordship has referred, Lordship. They are also, Lordship, they have sought for, Lordship, but in their representation, they have sought for reinstatement, Lordship. And that was considered. Apart from salary, is consequential, Lordship, benefits if he is reinstated, Lordship. Otherwise, he was terminated in year 1998, Lordship.
When did he retire? Retirement?
Retirement, had he been in the service,
Service.
2019.
Huh?
2019. 19. Then kindly come to page 81, Lordship.
What
This-
you paid a pension. Your termination itself is.
No, I'm coming. Let me complete. Always liberty is there, Lordship. I'm coming to that point, Lordship. Kindly come to page 81, Lordship. Speaking order, Lordship. This is in terms of
This has not been put to challenge.
it has been not put to challenge, Lordship. Then, Lordship, kindly turn to next page, Lordship, 82. I'm reading from second paragraph, Lordship. Reading from second paragraph. Whereas, despite of the issuance of, I think, page 82, Lordship, paragraph 2. Whereas, despite the issuance of the termination notice, there was no response from Sri Joram Allah even after expiry of given period. Finally, when the department did not receive any communication from him, Sri Prabhat Gogoi, a contingency driver, was appointed on officiating capacity in year 1998. Finally, Sri Joram Ala submitted a joining report on 21st July 1998 in the office of the Director of so and so publicly, which was rejected by the office in accordance with rule so and so as period so and so and so and so. Next paragraph. Whereas Sri Joram Ala, after this, submitted a representation to Home Minister on 29/9/1998, praying for regularizations of his service by cancelling the termination order. Lordship. Here, Lordship, so for communications of this termination order is concerned, Lordship, it was served to him. He filed representation to the department, Lordship, which was rejected. So therefore, the observations, the reason given by the learned single bench is not correct, Lordship.
Let's see the representation after the termination,
Lordship, see.
where it is. It's not a part of the record.
It was not a part of the record in the writ petition, Lordship. So therefore, it was not. Even then, it's part of the records only.
Part of the writ petition.
It was not a part of the writ petition.
It was not part.
It was not a part of the writ petition, Lordship.
The Home Minister.
Home Minister, Lordship.
It is to the Home Minister.
It's going to be highest.
Political boss. It's not a part of the writ petition. Why we should consider it?
Lordship, just since it was a part of the records,
Record was produced
and then kindly come to page.
before the learned single judge.
It was not produced. Then kindly come to page 69, Lordship. Then kindly come to page 69, Lordship. Annexure 10, Lordship. Because apart from this very representation, another representation was filed before the director. Even that has been referred in this very representation which I have produced, Lordship. Kindly come to page 69, Lordship. How it has been considered, Lordship. This is the part of the writ petition, Lordship. It was part of the writ petition. Page 69, Lordship, Annexure 10. As asked for by the Secretary, I appear necessary medical certificate in respect of Sri Joram Ala, driver for his long treatment has been submitted and place at page so and so order treatment with effect from 9/12/1996 to 19/7/1998, Lordship. For order likely to end so and so. Then he joined thereafter how it has been rejected. Kindly come to the below, Lordship. As per provision to rule so and so, essential so and so, no case can be reopened after expiry of 3 months from the date of notice served on the temporary employee. Notice was issued on so and so. Medical report from Medical Superintendent District Hospital 0 states that Joram Ala was suffering from chronic infective hepatitis from 9/12/1996 to 19/7/1998. The law is not permitting any relaxation.
No, Mr. Tabin, that's why I'm saying, we're saying that if you cannot terminate him by invoking the rule 5.2 of CCS temporary rules,
Lordship.
with the question of it falls.
Lordship, why I'm Lordship? I'm just trying to Lordship the reason given by the learned single bench.
No,
So
the
the region 2 is concerned.
Finding second finding.
Second is concerned, which is
So
then,
second, we may not go.
okay. Then I'm coming to third Lordship.
No, first.
No, because
Well, if you agree that
My
the
third-
termination of the petitioner by invoking wrong provisions, the provisions which is not applicable, what's the question? Termination fall flats.
Lordship, third is on the issue of maintainability Lordship. When there is a delay Lordship, the writ petition cannot be maintained Lordship, which is not explained at all Lordship. 18 years which has not been explained Lordship. I'll place one judgment Lordship.
You read the learned single bench judgment properly.
Therefore, Lordship, kindly
First is you could not have terminated because you have invoked the rule which is not applicable.
Lordship.
Which ought not to have been made applicable, which is not applicable at all.
Lordship.
Even if it's applicable, then second comes. So once you accept that, and when it is true that you could not have invoked this rule for termination, matter ends there.
Lordship, the paragraph 10 of the judgment Lordship. In the last what it says Lordship. Where it is a termination notice of year 1998. Although we are inclined to hold the writ petition to be maintainable, for the reason that medical documents are placed on record showing that the petitioner was not in an appropriate condition to have approached this court earlier Lordship. Had it been gone against the petitioner Lordship, the writ petition would have been dismissed Lordship. The questions of
obviously, if
questions-
it goes against the writ petition, obviously writ petition will be dismissed.
Therefore, Lordship, there is nothing on the records to satisfy this honorable court Lordship that he was the medical reason to for not approaching this honorable court Lordship. He has produced one certificate, that is, if Lordship see the medical certificate, which certified that up to year 2000 only he was medical unfit Lordship. From 2000 to 2016 Lordship, nothing has been
Tell
produced.
us, if the termination could not have been done
Lordship.
under the CCS temporary rules,
Lordship.
which rule would have applied? Which rule would have applied?
Lordship, CCS rules, see, here Lordship,
Then, so you cannot, if termination is bad, consequence will follow.
Lordship, there's something issue of the Lordship delay also Lordship.
Delay have to be considered on medical documents. Okay, anything else?
Lordship, I'll produce one judgment Lordship.
What judgment?
On delay,
Okay.
delay.
It's all settled laws. What's there? We'll decide on the facts of the each case.
Lordship,
Anyway, place it.
Lordship. And apart from that Lordship, it's admitted position Lordship, he did not join Lordship. After period of unleave is completed Lordship.
That's why no salary.
Lordship. And this admitted position Lordship. Accordingly, he was terminated Lordship. Notice was served and he was terminated Lordship.
Your termination itself is bad.
So
He has been wrongly terminated. He has
Here-
been
here,
terminated
Lordship-
applying the
here, Lordship-
provisions which is not applicable.
here, Lordship, one aspect, just Lordship, it came to my mind, Lordship. Here, the wrong invoking of the Lordship rule.
What is the right rule? Tell us.
Lordship, notice
Why you have not done?
opportunity has been given, Lordship. It's not that opportunity has not been given, Lordship.
And it doesn't. It doesn't indicate by your this page 81. You said, in spite of service of notice, it doesn't indicates anything that notice has been served to him or not.
Lordship,
It's categorical by the statement that the notice has not been served.
no, that statement is not.
Apart from this,
No, it is not there, Lordship.
So we have to presume,
In the writ petition, it
because
is-
he has written a letter to the political boss.
Lordship, in writ petition, it is not their lordship, notice was not served to them. In writ petition, that's also not pleaded, lordship. So per notice prior to termination.
It's okay, give the citizen. Facts we have understood. Law also we have also understood.
Lordship.
Private pasai.
Okay. Okay. Here, lordship, the petitioner was lordship terminated in year 1996, lordship. In the
Invoking wrong provision.
here, lordship, not the
Hopefully-
wrong,
hopefully
wrong-
not.
not the wrong provision, lordship. He was terminated.
Appropriate provision.
Yeah.
Then
Lordship, the writ petition was filed after 15 years, Lordship. Writ petition was here. Then observations of the Honorable Supreme Court, kindly come to page para 7, Lordship. Para 7 and 8, Lordship. Considering the,
aforesaid facts and circumstances.
yeah, I'm coming there, Lordship. Considering the opposite facts and circumstances, as such, the learned single bench ought not to have entertained the writ petition in the year 2012, challenging the order of termination passed on 16/12/1996 on the ground of delay and laches alone. At this stage, it is required to be noted that even despite the fact that it was specifically paid by the respondent in the writ petition before the learned single judge to direct authority to decide the appeal prepared by her husband, the learned single bench, despite the above prayer and pending appeal, enter into the merit of the case and quest and set aside the order of termination that is so and so. Here, what I'm pointing out is, Lordship, keeping aside all merit, Lordship, what it observed, Lordship. Not the Lordship, whether it was wrong, the initial termination is legal or illegal, Lordship. When it's not maintainable, Lordship, the court would not have gone into the merit, Lordship. There is then kindly come to paragraph 7, 8, Lordship. The submission on behalf of the respondent is that the termination on 16/12/1990 was absolutely illegal and against the principle of natural justice is concerned. Once we hold that the writ petition was barred by delay and laches, thereafter the merits are not required to be considered. As observed here and above, the learned single bench err in entertaining the writ petition in the year 2012, challenging the order of terminations passed in the year 1996 on the ground of delay and laches, and more particular when even otherwise, if the termination order would not have been passed, the deceased employee would have retired on so and so, so and so and so. Lordship, here, Lordship, Honorable Supreme Court emphasized that when this delay is not, Lordship, at all, Lordship, explained, Lordship. Questions coming to the merit does not arise, Lordship. Here, the legality or illegality of termination order. Here also, Lordship, legality and illegality of the termination order, Lordship. Whether it was illegally or legally, Lordship.
Difference is,
That
it's what as per the proper procedure.
Lordship, that part has not been, Lordship, noted by the Honorable Supreme Court, Lordship. Honorable Supreme Court noted the Lordship.
Simply says there's a delay,
No, it said,
therefore it could have been entertained.
no,
That's all.
it said, Lordship, the learned, the court below should not have entered into the merit of the case. Lordship. That is the legality, illegality of the order, termination order. When there's a delay,
In the facts and circumstances of that case.
no, Lordship. To my understanding, it does not talk about those things, Lordship. Otherwise, that would have been reflected in this very observation, Lordship. That this is the circumstances, and under this order should not be
The
entertained.
the words says so, which you have read.
Lordship, if Lordship read the Lordship, the inter judgment, Lordship, it talks about the Lordship, how when Lordship, he was terminated, then when he approached the court, these are the facts only, Lordship.
Okay.
The delay is there,
We'll
Lordship.
consider.
Here it was a termination followed by a appeal. And in the meantime, we died. And thereafter, the Supreme Court said, we will not go into the merit because of the delay. Para 6.
Lordship, here the para 6, Lordship. In year 1996, he was terminated, Lordship.
2009,
2009, he died, Lordship.
And
In year 2012, writ
What-
petition was filed.
Wife approached the writ court.
One line of thought.
Lordship.
Is it permissible for an employer to terminate the services of an employee because of not showing it? And he was a driver. He was a driver, is a necessary, is it permissible that you can terminate, forget the invoking of a wrong? Can you terminate a regular employee? Say he is not coming to office for a long time. Is that option open to you?
Lordship, so far termination is concerned, Lordship. When he did not attend the office, Lordship, notice was served, and when he did not join, he was terminated, Lordship.
Is that?
However, that is recognized under the rules, Lordship. That aspect, Lordship, we cannot now, Lordship, we cannot amend all those things. We cannot, Lordship, improve all those
It's okay.
things.
Yes.
And that apart, Lordship, one citation kindly that may be noted, Lordship.
Give it, yeah.
That is, Lordship, 2004 12 SCC. 2004 12 SCC. 217.
12 SCC 217.
217. This is quoting of wrong provision, Lordship. And just I'd like to read paragraph 7 only. I just read from here only, Lordship. Lordship, just it is well settled that if any authority has a power under the law, merely because while exercising that power, the source of power is not specifically referred to, or a reference is made to a wrong provision of law, that by itself does not vitiate the exercise of power, so long as the power does exist and can be traced to a source available in law, Lordship.
So that's
The director who terminated, Lordship, he had the power, Lordship.
issue a notice and
Though
issue a notice and terminate. No proceedings
Lordship, here,
for a regular employee.
here,
That's
Lordship,
basically what we're
here,
trying to
Lordship,
tell.
so far proceeding is concerned, Lordship. Basically, proceeding is drawn, Lordship,
It's
when
back to square again.
when it's disputed, Lordship. But here there's no dispute, Lordship, because he was served the notice, he did not reply, Lordship.
It's betrayal. Anyway. Yes. Sir, have you read that classic story of Rip Van Winkle,
No, man. I have not,
American short story? Rip Van Winkle.
I have not read.
Who went to sleep and wake up after 20 years.
It is their contention, man.
No, it is the fact, a story,
But here in this case, the story is quite different, man. As a matter of fact, my lord, they are contradicting two things. One, 1996, he was terminated. Then again, 1998. Whereas till 98, he was drawing salary. There he was drawing salary. And he was suffering from the illness. That is, his cause of the disease was liver cirrhosis. And he was confined in the general district hospital 0.
98, and you filed a writ petition 2020. After how many years?
As per my view, my lord, only my lord 2 years. Because the department could not produce the service book. He was posted initially at Daporizo, and from
24
there,
years. 24 years.
Yeah.
After 24 years.
No.
It's more than Rip Van Winkle's story.
Let me complete now. From Daporizo to 0, from 0 to Nahalogon. So when he was transferred to 0, Nahalogon, after transferring from 0, service books had to be sent from 0. It was sent, what, in the office,
In which year? After 98.
94. 94.
No, we're talking about after your termination from 98. From 98 to 2020, where you were and what you were doing.
Yes, exactly. My lord, the petitioner, every day he used to visit the office, but he was driven out from the office. Your service book has not been received. Without service book, we cannot do anything. So he was continuously from 2001, he was attending office, but the authorities did not allow him to join. So continuously he was up to 2016. He has to file the first writ appeal, which was dismissed. by the-
2016,
Yes.
16.
16,
It was
2000.
not dismissed, it was allowed.
Allowed, but
Direction was-
representation was not
Direction should
considered.
be considered.
Not considered.
But
So we-
you have not challenged that also.
That was actually done by some other advocates. I have no any idea.
That cannot be.
I came in 2020.
Sir, that cannot be an excuse. Sorry.
They are also, my lord, the service book along with the other documents could not produced by the respondent authorities. In the service cases matter, my lord, the service book is very much essential. Without that, authority cannot pass any impugn order. But in the instant case, in spite of his all effort, he was denied to join in the service. I think ultimately he had been to highest authority, that is Home Minister. And
What-
thereafter repeatedly he has submitted the representation. So there is no any lapse on the part of the petitioner, man.
There's so many lapses. Not only one.
As per the my lord record, the respondent authority may say so many things, but without producing the record before this honor court, it is difficult to point out.
That's why we have asked him, he said it was produced. And
No, it was not produced.
Records
So
were
Tuto also, it was asked to
It
produce
was not produced.
record.
Record in the
Where is the
sense
record?
that his
Service book was
service
essential.
is missing. He was at 0, and when he was transferred from 0 to Itanagar, Lordship, they said they have sent, but they didn't reach to the office, head office here. Lordship.
If you can come to page 66, the submission of this, just to test that, page 66. And check it.
That's 66 certificate.
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 You submitted the certificate.
Yes,
This
it
is
was
of 2001.
2021. Yeah,
So 2001, the certificate says that you are fit to join.
Yes. yes.
But you were dismissed in 98. So why didn't you approach court at that point of time? Immediately.
My lord,
You are
that,
fit from 2001.
Yes.
Because there is no other certificate saying you about your 80 years up to this. So from 2001 to 19 years to 2020.
he joined, my lord.
You were not allowed. Then what prevented you from coming to court?
But I think it is a very remote area and he does not know the legal implication.
That is why you, the service, the termination notice did not reach you because you are in a remote area. They sent it.
Hmm.
Their permission would be there.
Okay.
If you find any judgments relevant to this, you can
Lordship.
both.
Lordship, that the 2004, the judgment, the paragraph 9, Lordship. That is noted.
No,
Well,
you can put it. This one-
My,
Yeah,
my,
para 9, Lordship. And
this is
apart
my
from that,
prayer.
Lordship, I'll be submitting,
It is my
if
prayer that let the service book may be produced.
Which is not there, how can we direct them to?
So then they cannot, they cannot take any action.
You show us documents that you had given them letter in 98 that you wanted to join. In 2001.
Yes, it is there, my lord.
Where?
It is there. And today, actually, I don't, because he submitted the joining report. And I think joining report, my lord, I have, my lord, my lord,
Mr. Council, you cannot submit a joining report in 98 because your own medical certificate says 96 to 2001, you were not fit for duties. If that medical, every document has to be given some meaning. So that document, till 2001, you are bedridden.
One more thing, suppose if we hold that your combination is bad, you ought not to have been nominated. What benefit will can be given to you now?
my lord,
Had you been in the service, retired in 2019?
yes. My lord, as per the, my lord, the provisions of the, my lord, FRS,
What is that?
the employee has a undisputed and basic fundamental rights to get the benefits of the his service rendered to the state government. my
That's
lord.
why you have not rendered. Till 98, you have not, you have rendered?
The
After-
earlier, my lord,
after-
earlier it was already
Ah.
rendered. That person, that area, that areas of the salaries are still there.
Up to 98.
Yes.
That you have not made a challenge. Honorable single judge has said you are not entitled. You have not presented the appeal against that.
And secondly, my lord, your salaries given by the state government is not by a simple order. You cannot snatch away the basic.
That argument you can't take because of the finding of the authority. It is by the. You have not prepared an appeal. But what best do you expect?
Only,
For the
as per the,
PDT
my lord, observation made by the learned single judge, my lord. He should get the benefits of the all benefit, pensionary benefit. my lord.
Okay, we'll consider. We've heard Mr. Estapit Lamit's senior government advocate for the appellate. And also heard Mr. T. Learned counsel for the respondents. Hearing concluded, judgment reserved. All right.
By Tuesday, till Tuesday.
Lost.
If you can get.
Yes.
There are judgments.
Lost. Yes.
You also, if you have that, anything,
Judgments, any judgment you can
Yes.
give till Tuesday.
list this matter before any other appropriate bench without me. Yes. 24. Why? What do you want? 28. 28 Monday, it's not possible. After 2 weeks. Huh? After a week. On the prayer of Mr. Ensor, learned counsel to the petitioner, list this matter after a week. No, just Mr. Ensora, just delete that. Mr. Ensora, learned counsel, appearing on behalf of Mr. M. Kato, submits that his senior, Mr. M. Kato, learned counsel, has some personal difficulty for which he prays for 1 week time. Mr. Where list this matter up to a week. Yes. Yes.
They are working in the same department, that is medical department. And
What is your, you are radiographer and you are claiming parity with? Okay.
Earlier edition is 4,100 to 6,000.
Please,
Yeah, 59.
will issue notice? Heard Mr. T. So learned counsel for the petitioners. Also heard Mr. N. Ratan, learned additional advocate general. For respondent number? Who entered appearance on. You just get the number. Respondent who entered appearance on behalf of respondent number so and so, you take that. And Mr. R. Koyu for learned counsel for 7 and 10. 7 to 10. 7 and 10. And private respondents are there. You appear for that? What's there? Is it an autonomous body? I don't think so. A high power committee is constituted by the government only.
In that event, my lord, respondent 1, 2, 6, 8 and 8. 8 and 9. 7 and 10. My learned friend will appear. They have the standing counsel for health department.
In that case, you appear for all. 1 to
1 to 6.
1
8,
to 6,
8
8,
and
9 and 10. Huh? By filing this application, the petitioner press for a direction for enhancement of scale of pay of the petitioner.
With great pay also, man.
With
With great pay also.
great pay. In parity with the other employees in the department. By claiming equal pay for equal work. Issue notice returnable by 4 weeks. The learned counsel for the petitioner shall provide extra copies to the learned counsel for the respondents
Not so.
within 2 days.
Okay.
This after 4 weeks.
Obviously.
Yes, I'm my lord.
Yes.
My lord, I am impugning the order dated, my lord, 2/6/2023, my lord, passed by Deputy Commissioner Capital Complex, my lord.
Page
33, my lord.
33.
33. But now, before coming to impugn order, what happened in this case, my lord? I will start with my lord. This, my lord, page number 20, annex number 2, my lord. Page number 20, annex number 2, my lord.
Said.
My lord.
Proceed.
Preliminary notification issue, my lord. Accordingly, after claim and objection, my lord, at page number 23, annex number 4, my lord, was passed by the Deputy Commissioner, my lord. Now, my humble submission, my lord, once this order has been passed under the Act, my lord, the subsequent order, my lord, this is impugn order is based in law in the sense, my lord, once he has, after hearing the party, he has passed an order, my lord, he become punctus officio, my lord. There is no provision as such, this is enable him to pass another order, my lord, on the complaint of the private respondent, my lord.
Award has been given.
Pardon, my lord.
Any award?
No, my lord, no, my lord. I would say, my lord, the annex number 4, my lord, is in complaint, no award, that in terms of the law, my lord, he has reported to the competent government, my lord. That is correct, my lord. He can do, my lord, under section 15 of the Act, my lord. He has authorized, my lord. Now, once that has been, he has been exercised that jurisdiction, my lord.
What is the stage?
Stage, my lord, that
Preliminary notification issues.
issue, my lord.
And then,
Claimant objection heard, my lord. In according pass, he one order, my lord. That is 9/5/2023, my lord. In this order, my lord, he has remanded matter remanded the matter to the appropriate government for appropriate decision, my lord.
approval,
Not
appropriate decision.
appropriate decision, my lord. Now,
Is-
once he has exercised that jurisdiction, my lord, this act does not authorize him to pass another
No, what he has to complete the thing, he has to pass an award.
award.
That's all.
That
That's why I'm
is
asking whether the award has been passed.
no, not yet, my lord. As government is yet to take decision, my lord. In terms of his past order, my lord, he has not taken decision. He is yet to pass the award, my lord. Now, my case before my lordship is that my once
Suppose if there's a dispute of ownership,
my lord,
what is the procedure?
my humble submission with
You are claiming that the lands belongs to me.
yes,
Other person, they are also claiming that lands belongs to them.
them, my lord.
In that case, while hearing the objection, what is the procedure under the act?
That is the that he have exercised on 9 that after hearing, my lord, there is no such provision to decide the title, my lord. But then after hearing and after his own report, my lord, he will place before the material to the appropriate.
What is his findings after hearing?
After his finding, he say, my lord,
There's a disputed
since except,
regarding ownership.
my lord, page number 25, his finding is since except Srimati.
Even if there is a dispute, can he pass an award?
No, I should, I'm not sure, my lord, but then maybe not, my lord. That's why there is a provision that, my lord, after hearing, he will place the matter before the appropriate government, my lord. Now, my humble submission, my lord,
What is that provision? Let's see.
section
2030.
15, my lord.
Section
15, my lord.
50.
15, my lord. 15.
15.
May I read this one?
Yes.
Hearing of objection. Any person interested in any land which has been notified under section sub-clause 1 of section 11 being required or likely to be required for public purpose may within 60 days from the date of the publication of preliminary notification object to the area and suitability of the land proposed to be acquired, justify offer for public purpose, the finding of the social impact assessment report. Clause 2. Every objection under subsection 1 shall be made to the collector in writing, and the collector shall give the objectioner an opportunity of being heard in person or by person authorized by him in his behalf or by an advocate, and shall, after hearing all such objection and after making such further inquiry, if any, as he think necessary, either make a report in respect of the land which he has been notified under subsection 1 of the section 11, or make different report in respect of different parcel of the such land to appropriate government, contain his recommendation of the objection, together with the record of the project proceeding held by him, along with the separate report giving there in the approximate cost of the land acquisition, particularly as to number of affected family likely to
No.
resettle.
It can be treated as a report to the government for appropriate decision.
Yes, my lord. Page number 25, my lord. This is his past order. My page number 25 is the part of this, my lord. The finding, his finding. My page number 25, my lord. Last, I'm reading from last para, my lord. Since
There is a
except
change in the situation.
truly, my lord. Truly, my lord. No, my lord. My humble submission. This the authority under this section 15, my lord. He has exercised, my lord. Accordingly, what his finding is, since except Srimati such and such, this is me, my lord, all the prisoner of the WPC number 87/2080 other could not produce any convincing substantial documents to prove their ownership over the purpose of acquisition of lane at helipad Naharlagan, and therefore the claim of all the writ petitioner and other are hereby rejected or stand ground, and matter is placed before the secretary LM for his further necessary action as part of my lord.
You are not challenging this.
I'm not challenging me.
He said, finally he said, place before the secretary LM.
Yes, my lord.
According the order has been passed for placing. That's
Yes,
all.
my lord. Yes, I could not challenge this. This is in terms of the law, my lord. This is provision under the law, my lord. On he can recommend so, my lord. So I'm not challenging him, my lord. But the subsequent order, my lord, same, my lord. Once he has exercised his authority under the law, he
What does
becomes
it say? Impugn order, what does it say?
same, my lord. Is impugn order, my lord. Impugn order also, my lord, will list page number. If my lord kindly turn to page number 35, my lord. Last second line, page number 35. The applicant
The proceeding will be claimed of this is.
that is member of Nalagan Helipad Lane Effective Forum and Simoti Sasson is hereby direct to approach the secretary lane for redressal of any grievance, if any. All the representation documents submitted to the office of the undersigned is hereby forwarded to secretary lane management in original for his perusal and decision, my lord. Same order, my lord. But then my grievance is, my lord, once he has exercised the authority under the law, my lord, he become punctus officio, my lord. At the instance of, my lord, this private respondent, he cannot pass this subsequent order, my lord.
There is a change in the circumstances, situation. Who is appearing for DC? You.
For Deputy Commissioner, Lordship.
Ah.
Actually, this is the same case with the Bamang Roy one, which was in contempt. In that a single judge order, Lordship, it is in the order, it was in the end, it's written deemed acquired. The land may be treated as deemed acquired. So
Now, what is the-
payment was
what is the-
directed to
Latest status. Payment has to be made.
within 6
Only you
months.
have asked for the,
Within 6 months.
hmm.
Within 6 months. And those petitioners in Bamang Roy, they were the persons who were in that periphery. They were the one who
It's not
were
the same land.
who were disclosed from the
It's
area.
not the same land.
Same land, same land. This is the same land.
Total lane, my lord,
Their
they are proposed to
home
acquire
was-
is 7 point.
Their home was bulldozed. So this petitioner now comes in and says that she has the LPC of that land. Just because the government is sanctioning an amount of 31 crore here, she have said that this should be,
Given to her.
this may not be dispersed.
My lord, that
This
is
cannot be,
We cannot stop.
this cannot be.
my humble submission, my lord.
You
The
may,
total-
you be an entrepreneur somewhere in the.
She was never there. When it was
Well, just simply
bulldozed,
not issue notice. Because we cannot stay this.
No, my lord,
when it was bulldozed, she never raised
This
any
will make the
any
things
question.
upside down.
no, my humble
This
submission, my
will
lord.
create more problem.
My lord will kindly,
Then the resolution.
my lord will give me 5 minutes, my lord. I would say, my lord, before the DC, my lord, suppose in case of dispute title also, my lord, I have 2 lane LPC, my lord, issued by the competent authority, my lord. That is not disputed till that, my lord. Till that, nobody challenging, I am my lord. Now, in terms of my lord, know the law, my lord, the person, my lord, possession of the land is the base owner until and unless the real owner come, my lord. Now, there is a documents by the government, the competent authority, my lord, showing that I am the owner of the land, my lord. And the submission that, my lord, oh, this land is
No,
totally
there
not
was-
same, my lord.
There was a writ petition. It
Who-
was taken to appeal.
That was not necessary, my lord. Yes, I was not a party, my lord. My lord,
Whether you are a party or not, that is something
no,
different.
my lord, my lord,
Buildings were bulldozed.
my lord,
Hearing was taken there itself
Ah.
in the helipad itself.
in the writ petition, my lord, if I have copy of the writ petition also, my lord. My lord, in the writ petition, my lord, there was no specific mention of the lane required, my lord. Now the government is trying propose to acquire, my lord, 7.68 acre, my lord. 7.68 acre, my lord. Out of this, my lord, my lane would be, my lord, my lane would be, my lord, only the 17,069
How much is the total Proposed, total land proposed to be increased, total area.
7.68 acre, my lord. In term of square meter, that would be 31,790.8.57 square meter, my lord.
Then
My
Yours-
lane, my lord, out
your
of
lane-
this, my lane would be 669 square meter. In their lane, my lord, private respondent lane would be 13,410, my lord, and 8.857 square meter, my lord. This is not the same lane, my lord. The read petition, what they are trying to say, my lord, the proposed lane equal, my lord, total 7.6 is all, that is the part of read petition.
So
That is
this-
not true, my lord.
yours is around 16.
My 17, my lord, 17,660.
Those in this writ proceedings and contempt proceedings is 13,000.
13,410, my lord.
Is it correct?
Lordship,
Yes, ma'am.
at this moment,
Lordship,
this is,
That has not been figured out, even in
Yes,
the
Lordship.
contempt petition and writ petition.
Because, see,
Private respondent.
you cannot pass an order which may be in the teeth of division bench judgment order.
No, my lord, I'm not saying so. I'm not praying for anything,
So
my
you
lord.
should notice.
But
That's all.
this, my lord,
Only that,
order, my
yes.
humble submission, prima facie, this is without
If-
jurisdiction, my lord. The impugn order, my lord. Impugn order without it. Other than there is earlier order, my lord, may order, my lord.
We'll treat this impugn order as a report of the collector.
That is already, that
Because
report,
this first order, which you are not,
Then-
which you have not challenged,
my lord.
it clearly says placed before the secretary land manager.
My lord.
So you have not challenged this.
No, my lord, I'm not.
It's just a consequential order offshoot of this first order.
No, my
which you-
lord.
Which you are not agreed.
No, my lord. If my lord, I may allow to read the whole this impugn order, my lord. That is totally, my lord. Hearing was done, my lord. Claim and objection, my lord. I said there is no extra provision that allow the deputy commissioner to have to claim an objection, my lord. Once he is,
But we cannot.
if my lord,
We cannot stop the disbursement
I-
in view of this other cases.
my lord, I would say, my lord, if even if my lord stay impugn order, my lord, there will be no stoppage because as there is already order by the deputy commissioner placing the report before the competent authority, my lord. That is in May, my lord. 9/5/2020. This is already there, my lord. I'm not impugning that, my lord. That is already there, my lord.
That's what I'm saying. If you are not agreed of that
My lord.
first order, it is a consequential order placing before the LM secretary.
No, my lord. This is not. Not my lord. Allow me to read all this
No,
impugn order.
after hearing all the parties,
My lord.
the affected landowners,
My lord.
he has decided whatever maybe the reason, he said finally it should be placed before the secretary.
My lord. That is already
Accordingly,
there.
and your impugn order has been passed, placing the matter before the secretary. That's all.
No, earlier also, my lord, in 9/5/2020 order also, my lord, the state ground in the matter is placed before the secretary LM, my lord.
Yes.
Already that is has been placed before, my lord, the
Ah.
secretary, my lord.
Hmm.
Now, once that has been done, my lord, in terms of the law, my lord, my humble submission, my lord, there is no authority as such, my lord, to renew, my lord. If this is LM, my lord, tomorrow also, my lord, he is make another report, third report, fourth report, my lord.
We'll adjudicate it.
My lord.
Let them file a counter affidavit.
My humble submission, prima facie, my lord, this is.
No,
without-
your entry prayer, I'm on entry prayer.
My lord.
Your entry prayer not to disburse. That we cannot.
My lord.
We may stay this, but we'll clarify.
Hmm.
Disbursements will be done.
My lord.
What's the meaning in that case? You have not stayed of this impugn order, prayed for a stay of the impugn order. You have prayed for not to disturb, not to disperse.
Right.
Is it?
My lord.
Disbursement in view of the pendency of contempt and the order of writ petition as in as the writ appeal, judgment of the division bench. Disbursement we cannot.
No.
So we'll issue notice.
My lord.
All right.
My lord.
Sure.
Sure, my lord.
Administered learned counsel for the petitioner. And also Understand. Who is for 1 and 2? Who is 1 and who is rest? Mr. E. Kamli for respondent number.
No, sorry, I'm only for one.
Sterling conflict with the land management. Entered appearance on behalf of respondent number 1. And you have met these parties, Bamang Roy.
My lord.
This could be something behind the scene or what?
This
My lord,
cannot
he is
be
necessary party, my
acceptable.
lord. Yes, he is representing the other side, my lord, of the, he is one of the claimant.
That is the precisely the reason that it's contempt is pending.
My lord.
And in respect of this respondent number 4,
My lord.
it has been settled. They are entitled, they should be paid.
I told him he is necessary party, my lord, in this case, my lord. Yes, my lord, he is representing the land, my lord.
That's what I'm saying. They are the person who are supposed to get the compensation in terms of the order of this court. Sir, there is something.
No, my lord.
There's something behind the scene. And you see at page 19, he or she,
See,
Sri
See, my lord.
Techimania,
My
why
lord.
no, Sri Techimania, wife of Sri T.M. Tara.
TM Tara, my lord.
But before that, Sri Techimania.
But my lord, there is a photo, my lord, of her, my lord.
Huh?
A photo of her, my lord.
Who has changed her agenda? GFA for learned addition senior for respondent number
2,
2 and
only 2.
who is for 3?
3 is
Okay.
a foreign person.
By filing this writ petition, the petitioner has challenged the order of Deputy Commissioner. Order number so and so, page 33. Dated 2/6/2023. Passed by the Deputy Commissioner, Public Collector. Whereby the claimant objection issued by the official of the Deputy Commissioner has been closed by placing the matter before the Secretary Land Management. And directed the land affected parties, including the petitioner, to approach the Secretary Land Management for redressal of any grievances. Mr. L. Permit learned counsel to the petitioner submits that the Deputy Commissioner being a collector after issuance, publication, preliminary notification, and hearing the objection of the land affected parties, including the land affected persons, including the petitioner, is not empowered to place the matter before the government. As the Deputy Commissioner is obligated to decide the matter in terms of the section 15 and in terms of the provision of right to fair so and so, 2013. You just take that. The only provision which the petition, the deputy commissioner or the collector would recourse to is section 15 of the right to fair so and so and so and so act, That's issue notice, returnable in 4 weeks. The learned council, the Mr. D. Kamduk, the standing council, and Mr. G. Since Mr. D. Kamduk and learning standing council and Mr. M.S. G. and additional senior government have put their appearance, no formal notice need be served. However, extra copies be served to the so and so, The learning council will petition shall take steps for response number 3 and 4. We register post with AD as well as users for within 2 days. This after 4 weeks.
Okay.
Item number 3. What is this? How you can drag the people like this? Can you drag out?
That's it.
Can you drag out the people like this?
No,
The citizen of the country.
whatever is been is
What is the
unfortunate.
violation? Constitutional right, the fundamental right. What is the provision? Sir, what is the provision? Please tell us.
Article 21, Lordship. 21. 21, Lordship.
Not 21, Article 19. Right to settle anywhere in the country.
That too also.
19 what?
19, Melod,
Clause
19,
what?
1E.
It's a serious matter. There's a procedure. If there's a violation of inner land permit or something like that.
Obviously, there is wrong on the part of.
Even the foreigners cannot be set up like this. But to talk about the citizen. Then it comes to the prisoner, Article 21. Is it a jungle right?
No, Lordship.
There is no rule of law.
Seems, Lordship, there is admittedly gross violations.
This court takes it takes a serious view of the matter. Will issue and list it after 2 weeks. You come with the instruction.
Melod, in the meantime, Melod, the impugn order may be stayed.
What is the intent?
Page number 34, Melod.
34.
34. By this impugn order, Melod, my ILP has been cancelled.
What can we do? We'll take, let him come with the instruction, we'll pass appropriate order.
Melod, pursuant to this impugn order, Melod,
Where he is now?
he's in Assam, Melod.
Let him be there for.
Melod, why I'm making
It's within the country.
but Melod, why I'm making a prayer for interim is because, Melod,
Page 34.
34 is the interim order, Melod. Melod, may kindly come to page 36.
Hmm.
On the very next day, his ILP was seized and he was forced to leave Changlang district, Melod. He was not even given time to take custody of the goods in his shop, Melod. The entire process was completed within 2 days, Melod.
What is the allegation? Is there any allegation?
Allegation, Melod, basically the reasons, there are primarily 2 reasons. Firstly, first reason is that the
Have
repeat,
you violated the terms of the ILP?
no, Melod.
Then
Nothing, madam. Very surprisingly, the first reason is that the repeated incidents of family dispute is indicative of violation of norms and guidelines for issue of ILP, madam. However, there's not even a single indication of which
norms I have violated. Secondly, my lord, it is on an assumption that there is a possibility of breach of peace and public order due to the activities, my lord. Activities, my lord, to reach this finding, the deputy commissioner has relied on past incidents of family dispute.
Are you involved somewhere like threat to the national security or something like that?
Of course, no, my lord.
Hmm?
No, my lord. Page 34, my lord, may kindly have a look at.
34.
34, my lord.
I've seen it.
Reasons, my lord, very simple reason.
Hmm. It involves the sentiment of the local people. But there is a ways and means to tackle this such a situation, problem, is not it? We'll ask for the instruction. All right. You want to be at Changlang?
Sorry, my lord.
Changlang,
Yes,
you want to be there?
Yes, my lord,
How long
because
you are there? Since when?
my father came in Changlang in the year 1981, my lord.
Hmm.
All the children, they were born and brought up in Changlang.
All of them have been said.
All of
chased
them.
away.
All of them, they have been externed from Changlang district.
External. Heard Mr.
R.L. Sambhaji.
Learned counsel for the petition. And also heard Mr. Ayrira, learned additional senior government. By filing this application, the petitioner has put to challenge the impugn order that is 6/10/2023, by which the ILP inland permit of the petitioner was seized, and the petitioner along with his family have been externed and forced to leave Changlang town on the same day. The learned counsel for the petitioner submits that the interaction has been initiated illegally pursuant to the joint representation filed by the Women Organization of Changlang Town before the Deputy Commissioner Changlang for cancellation of the inner land permits issued in favor of the petitioner and his family members. He further submits that interactions is in gross violation of the procedure established under the law. Issue notice, returnable in 3 weeks. Since Mr. Aydira learned additional senior government advocate, it enters appearance on behalf of all the respondents.
No, sir.
Or is there private respondent?
There are two private respondents.
The private state respondents. No one formal notice needed. No formal notice needed. Respondent 1, 2, and 3, huh? State respondent number 1, 2, and 3. Our extra copies will be furnished to them. The respondent, the learned counsel for the petition itself. They will take the steps for service of notice of respondent 4 and 5. By register for so and so, huh? Within 2 days. Suppose if we stay this, page 33 or which one, 34.
No.
Will it automatically entitle you to have the ILP? I don't think so.
No.
The manner. Next paragraph. This code takes note of the manner and method of seizure of the ILP, the externment of the petitioner and his family. Which prima facie appears to be. In derogation of the law, established procedure of law. On the next date fixed, the learned state, Mr. Irina, learned senior, additional senior government said. Place the instruction. For which appropriate order shall be passed.
If that be so, my lord, can it be after 2 weeks, my lord? Because that's
Huh?
if that be so, my lord, can it be taken after 2 weeks?
After 2 weeks, then returnable within 2 weeks.
And I will be allowed to take steps to dusty mode on respondent number
As
4
well
and
as,
5.
usual process as well as dusty. Huh?
Mashallah.
My please, Lordship.
Yes.
Lordship, here, by order dated 1/2/2023, the
Hmm.
petitioner was directed to implead the private respondent number 3.
Hmm.
Accordingly, she was impleaded and dusty service has also been taken. And to that effect, affidavit was also filed on 19/4/23. But as on date, she has not been represented.
When service was effected,
Lordship, on order was passed on 1/2/2023. Dusty service was taken on 6/2/2023.
Hmm.
And accordingly, affidavit regarding the dusty service has been filed.
Mr. K. Lolen, learned counsel for the petitioner, submits that.
It was already
the
filed on 19/4.
Newly impleted, the impleted respondent number 3.
Yes,
The service on impleted respondent number 3 has been duly served.
sir.
Mr. To that, duly served. To that effect, he has already filed an affidavit. Mr. Non-appears for the respondent number 3. This was service of notice. Mr. Asake and Ms. Swenson. Standing counsel for information. What?
Yes, ma'am.
Information Commission, huh? State Information Commission. Present. You are also appearing?
No.
No, it's only information. In view of this matter after 3
After
weeks.
one week, Lordship. Lordship, in the meantime, I will file additional affidavit by clarifying some certain issues,
You want to file additional affidavit?
additional affidavit within 2 days,
This matter after 2 weeks.
week,
2 weeks.
after 1 week.
After a week, so as to enable Mr. K. Lolen to file additional affidavit.
Yes. Deeply obliged.
You are not with the brief today, why?
Lordship,
Want to withdraw?
yes. Because I need some time at least to
Mr. D. Baje, learned counsel for the petitioner, fairly submits that in his usual fairness, submits that he may be allowed to withdraw the civil revision petition, right? Civil revision petition.
Wait.
Mr. D. Land Council respondent is present. Prayer is allowed. The revision petition, civil revision petition is permitted to be withdrawn accordingly. Withdrawn and closed.
Interim target.
With liberty to pursue the
Ah,
for the appropriate authority.
with a liberty to approach
Pursue
the appropriate authority. Appropriate authority includes those.
It's
That may create some confusion because Parwana has already been issued by the village authority.
Okay.
He will have to appear.
So village, we'll have to say village authority.
Yes.
With first, so and so, press for withdrawal of the civil division petition with a liberty to approach the village authority pursuant to the Parwana issued to the petitioner this time. Then that's it, allowed to withdraw with a liberty as straightforward. Okay.
all right.
Appointment of arbitrator.
Yes, Your Honor. This is a
Your
petition
Lordship,
under section.
There was some discussion regarding appointment of, there was a proposal from their side and department, they took
You
some,
need some time.
yes.
Okay.
Your Honor, but there's an admitted case of dispute, Your Honor, in the section 9 which has been filed and there's an appeal
It's
filed.
okay, wait for some time, you ultimately.
Your Honor, the
will-
matter is lingering
Huh?
for such a long time, Your Honor. It's just an
Is
appointment.
there, is there delay? When the cause of action arise?
The cause of action is 2020 when Your Honor, the report came.
Ah,
The report of came which made the project unviable. After that, we have filed a section 9 because.
have you gone through the latest judgment of the Supreme Court? 137 applies, Limitation Act, Article 137 applies.
Yes, Your
If it is beyond 3 years. you
Yes, Your Honor, I can prove this. Prove this right.
That's why precisely I'm asking.
Yes, Your Honor, the notice was issued.
When was the cause of action for reference
Yes, sir.
arose?
Yes, the cause of action arose when the report came and the project became unviable.
No, that is dispute.
Yes, Your Honor.
Thereafter,
Your
there's a
Honor,
provision for appointment
Yes, Your Honor.
by the parties.
one of the.
You have
clause-
approached the respondent.
Yes, Your Honor, one of
They
the.
refused to.
Yes, sir, one of the clause of the agreement says.
When it is started?
When the project came, report came, Your Honor, that's why I'm submitting, Your Honor. One of the clauses of the agreement says, if the project become unviable due to the fault of neither of the party, then my upfront premium, which is a form of security deposit, will be reimbursed to me. So once the report came, I am only seeking the reimbursement of my security deposit. So once they denied and they tried to terminate the agreement, I filed a section 9 before the district court. District court passed an order, stayed the termination of the proceedings. But the district court also orders that the arbitration should be continued. Meanwhile, Your Honor, the COVID-19 pandemic happened.
That's why I'm asking, when this, the time for the
Yes, Your Honor.
reference
Your Honor,
to the arbitration.
Your Honor, the notice
or
invoking
approaching for
arbitration,
appointment of arbitration
Yes, sir.
has
notice invoking arbitration was sent on 10th of July 2020, Your Honor.
21.
2020.
Okay.
In light,
2020.
in light of the Supreme Court's order, the Supreme Court gave us, there's a Supreme Court order of 17th June of 2020, which stated I have to invoke arbitration within 1 month, within 30 days. I sent the notice on 10th of July. I received the reply on 23rd of July, Your Honor.
23rd of July 2020.
Yes, Your Honor.
So when did you file this application?
It's 11th of July.
11 July.
Yes, Your Honor.
Then it's okay, it's within. That is what I
Yeah,
presume.
this is not a
It
time.
is sometime, we'll give.
Your Honor, if I can show one order, one prayer, it
No,
is,
if he's this, because he's contesting, he's saying there's something going on.
Your Honor, just one order, just one or two.
When we're not going to pass the, otherwise, if he agrees, I'll pass dispose of the matter today. It's an appointment of.
Yes, Your Honor, yes,
arbitrator.
Your Honor. You know, the thing is, Your Honor, when
He's asking for, your colleague is asking for some time, that's why I'm trying
yes,
to.
Your Honor, I totally bow down.
Then why I should to look into?
Yes,
Do I
sir,
need
this,
to?
this I want to submit.
To
one.
grant a time to, do I need to look into?
No, sir, Your Honor,
Okay.
Your Honor, just one submission, one submission. I have to
If it is not the ground for adjournment of the matter, I'll impose you a cost. Kindly, which page?
Yes, Your Honor. Your Honor, it's the order dated 13/12/2020 passed by this court, Your Honor, on page number 250.
250. 250.
Yes, Your Honor. Your Honor, this is the order by which the section 37 was disposed of by this honorable court. Your Honor, may come to page number 256.
Yes.
Your Honor, page number 256, second line. So this entire paragraph, the honorable court has recorded the objections of the state. Your Honor, the paragraph first, second line, the MOA says that the appellant is entitlement for refund of the upfront payment if the project is found not viable without there being any fault on a part of appellant, but in the present case, that project failed due to the fault of the appellant. Thus, the upfront payment is a disputed issue, and the same can be settled only through an appropriate proceedings. Therefore, there is no error in the order passed in the learned court below. Further, by taking steps for the adjudication of all disputes by arbitration by the appellant, has rendered the instant appeal infructuous. So, this is the first thing, Your Honor, they admitted to the dispute, and they only stated that it should be raised before appropriate forum, which is the arbitrative tribunal, Your Honor. Your Honor, now paragraph 11, Your Honor, on page 257. Your Honor, paragraph 11, last fourth line, Your Honor. The honorable court further recorded, he further submits that since the
You may
respondent.
be correct. What he's asking is sometime.
Yes,
Because
Your Honor.
he
yes.
said, why you want time?
Lordship, only,
Why do you want time?
because Lordship, there was a direct, Lordship, see this very judgment of this honorable court, Lordship. The party has been, Lordship, directed to approach the, Lordship, arbitrator, Lordship, to have the settlement, Lordship. Accordingly, they went to Supreme Court against that order, Lordship. Honorable Supreme Court also, they withdrawn, Lordship. And then, Lordship, they proposed some name, Lordship, and there was some sort of correspondence between us, Lordship. So just I wanted to take that instruction from the authority, the status of that correspondence. Lordship.
That's all.
They proposed for
Your Honor.
the arbitrators, Lordship.
You know, the arbitrator was proposed, they proposed the counter arbitrators, and the matter was never. Your Honor, section 10 says that.
So
Apart from that, Lordship, now they are asking.
You are not agreeable.
Your Honor, section 10 says that if there's a disagreement regarding the number of arbitrators, it can be only a sole arbitrator, Your Honor. That's why I'm approaching.
So
this.
therefore, whether it's agreeable or not, Lordship. Let me come with that
Your Honor,
instruction.
it's
Lordship.
the reply came in 2020. We have been trying to approach them. There was no reply. They have gone completely silent, Your Honor. And after 3 years also, when we are trying to agitate the same issue, it's the same status, Your Honor. Like we are still waiting. We are still waiting for the
Wait
point.
for another week. Well, obviously.
Your Honor, in that case, can I request one thing, Your Honor? I come from Delhi. So can it be a specific date given to me so that I can make travel arrangements, Your Honor?
You are in Delhi. You are
Yes, Your Honor.
practicing Delhi.
Yes, Your Honor.
Supreme Court or High Court?
Both, Your Honor.
Why you have approached the Honorable Supreme Court? And then you have.
You know, like on the when my interim.
Off the record, I'm just asking.
Okay.
What is the reason for approaching?
You know, first in the section 37 petition, our interim relief was denied. That's why we went to the Supreme Court, and Supreme Court said invoke the arbitration within 1 month. And after that, we went went to the Supreme Court to challenge the final order, but that was withdrawn because we wanted to do arbitration then. So since then, we were thinking that since the clause is self-sufficient to state that the project has become unviable, NGT also passed an order saying that I am not at fault. So, and that NGT order was not challenged at all. So it brought finalities. That's why we're seeking.
It's a project where? Which project?
It's
Which place?
Tawang River Basin.
Okay. Bilwara. So, heard Mr. So-and-so, non-counsel petitioner. Mr. Estafet, the senior government advocate, press for it. Granted 1 week time to obtain instruction. Instruction.
Yes.
This after a week. List on which date?
Yes, Your Honor. You know, any 20th December, Your Honor, 19th or 20th December.
29.
29, I think we will be having vacation. December, we are having vacation. After 22.
29.
20th December.
It's vacation.
No,
period.
it's vacation.
That's okay.
Before 23.
Prior to 23.
Prior to 23.
23rd is the last day.
So
Working day.
20th, 19th or 20th December.
20. 12/20/22.
All right.
Grateful, Your Honor. Thank you.
Counter affidavit,
My lord, I pray, my lord, some more time, my lord.
Lordship, this is
What-
only
what
the
is
case
the
of
matter?
matter is Lordship, this respondent number 2 Executive Engineering Power Department of Daporejo. They have ordered some supply work, electronic items, Lordship. So I am running a small shop, Papumpara Enterprises at Naharlagan, Lordship.
what is the work order?
Work order is Lordship, page number 16, annexure 2, Lordship. All total, their order was 46 lakhs 30,000.
Is it permissible?
So Lordship, that is,
Just a work order,
yes, Lordship.
no NIT.
No, Lordship, they have given the order, so.
Is it permissible?
As per the NIT, Lordship, that is.
It's been
Different.
given as per the NIT, pursuant to the NIT.
That is, we have not been bidden here, but Lordship, they have personally brought that executive engineering and they order for that. So accordingly,
Any dispute?
no dispute, Lordship.
Are you
So-
disputing it?
No, my lord, that's why I am praying some more time, my lord.
So, Lord,
I
only-
will give you 2 weeks time
Yes,
as a
Lordship.
last chance.
My lord,
You have to obtain what is the whether it's admitted amount or not, that's all.
Lordship, every day they are saying that plant is now not available, wait for no more days, so more month like that. Because of that, Your Honor, I am suffering. So we have filed submitted two representation before the executive Daporejo to release at least my bill. So I can run my shop also. So they are saying wait for next
We'll
March
give them,
like
2 weeks time,
all right, Lordship.
all right?
2 week, my lord, no, my lord, our process, my lord, for filing affidavit, my lord, we need to go through process, law waiting, my lord.
If it's so, you get the instruction,
Yes, Lordship.
and if there is an admission, we'll pass the order without your affidavit.
My lord, my humble summit,
And
even
if
if,
there is a dispute, if you dispute the entitlement, the amount, then we'll dismiss.
no, but other aspect of this matter, my lord, here, my lord, for my department, only executive engineer has
Who
been,
has to pay the amount?
Executive engineering Daporejo.
is the,
Who is appearing?
my lord, I'm executive
He is
engineer, my lord.
executive engineer.
Huh?
Now I am appearing for executive engineer, my lord. But
Then-
then, my lord, my humble submission, my lord, department can be represented by
would
him. It's the secretary should be a party, my lord.
Huh?
Secretary, my lord, of the department, my lord.
You have given, this is your whole problem.
Mm.
That's your problem only. It's not the
Yes.
problem of the petition.
Yes, Lordship.
You have given him work order, he got it executed, you have to pay. That's it.
And other aspect of the matter, my lord,
And how you get the fund, it's not his problem.
Yes, Lordship.
other aspect of the matter is, my lord, this is, my lord, is in my, this is bill of 2006, my lord,
Huh?
2016, my lord. Surely, my lord, the, my
Limitation.
lord, time wherein, my lord, claim, my lord,
Subsidiarily,
2016, my lord, time wherein cannot be, my lord,
subsidiarily.
my lord. That would be the.
That's why he wants, he wants that you should not file an affidavit.
Yes.
So I'm praying by some reasonable time, my lord.
2 weeks.
That's all.
Not Mr. So-and-so, Mr. L. Permit Land Council for the respondents, press for and granted 2 weeks time to file affidavit in
I love you.
opposition.
That's all right.
Please, my lord. From item number 8 to 14, the education department has yet to file their counter affidavit.
What is the matter?
This is termination of service.
Lordship, I am appearing on behalf of Rabat Agri. He's also the standing counsel for education. We have sought for the revised comment.
Is there new standing council?
Yes, yes, new standing council.
What about?
No, he is
He's
also there.
Okay. Heard Mr. So-and-so.
My lord, there are similar matter still pending for WPC 418 and 423.
Just wait. This is from 7 to
8 to 14. Item number 8 to 14.
8 to 14. So-and-so appears for petitioner. Mr. Arko, Land Council for the Land Council appearing on Mr. T. Tagum, Land Standing Council Education Department, praised for and granted 4 weeks time. 3 weeks.
3 weeks may be suffice.
3 weeks time to file counter affidavit.
My lord, there are another WPC, 2 more WPC, 418 and 423.
Writ petition number so and so and so
418 and 423.
be listed along with this writ petition.
Obliged, my lord.
You give the number.
May assignment. In attempt no 60, my lord, I was supposed to file affidavit in reply, my lord. I affidavit in reply, my lord.
Mr.
I,
Any private respondent?
no, my lord.
Mr. L. Preme, learned counsel for the petitioner submits the praise for and granted 3 weeks time to file affidavit in reply. MS so and so appears.
Oh, sorry, my lord,
Learned standing
private
counsel-
respondent is there, my lord.
Huh?
Sorry, private respondent is there, my lord. One.
Any. Steps. Service completed or not?
Completed, my lord. Last one, I think he appeared, my lord.
Hmm?
In the court, his also name is reflected, my lord. He is represented by learned counsel.
Non
R.
appeared.
Nabam.
Huh?
He is represented by R. Nabam, my lord. Nabam Regam, my lord.
Or
Nabam, my lord.
non appears for respondent number
7, my lord.
7.
Okay.
May I please? May I please? Your Lordship, I have filed this IA for the substitution of the respondent, alleged complainant, on the ground that the earlier respondent is retired from his service and there is a new incumbent in his post.
Will not substitute, will implement the new incumbent.
Okay.
Mr. I. Bam. Heard Mr. I. Bam, learned counsel for the petition. Applicant. By by filing this application, the petitioner. The applicant press for implement of Mr. Who is that new incumbent?
D. Ligo.
Huh?
D. Ligo. Or D. Longri.
D. Longri.
Yeah.
On the ground that the respondent number 1 has retired from the service. Mr. Next paragraph. Having considered the submissions, this court deemed it appropriate to allow this application, implementing Dr. D. Longre as respondent number 2. Listed. Accordingly, the respondent number, Mr. Dr. D. Longre be implemented as respondent number 2. Registry is directed to take appropriate step. The registry is directed to take steps. In view of the implement of Dr. So and so as respondent number 2. Mr. I. Bam is directed to take steps for service of notice upon respondent number 2, newly implemented respondent number 2. The registered post with the AD as well as usual procedure within 2 days. That will be in the main, huh?
Yes.
In view of the so and so. List after 3 weeks, 4 weeks.
May Lordship.
You're supposed to file vision there.
Yes, Lordship.
You don't want to.
Lordship, at least this matter after 2 weeks, Lordship. In the meantime, I will file, Lordship.
add Mr. G. Bam, learned counsel for the petitioner. And also who is for one?
For 2, 3, and 4.
Who is for one?
Land management.
None appears for respondent number one. Ms. R. Basar, learned government counsel for respondent number
2, 3, and 4.
2, 3, and 4.
Five for five.
Mr. D. Sophie for learned counsel for respondent 5. This matter after 2 weeks for admission hearing. In the meantime, learned counsel for the petitioner may file affidavit in reply.
Mashallah.
Your Lordship, the last occasion records were called for, Your Lordship. I have not received the records yet, Your Lordship. Some time may be given.
What is this?
My lord, what had happened is there was a dispute between father and the son.
Father and son.
Father and the son. The son is a what we call born out of extramarital. So then there was a series of litigations. And finally in 2017, there was one
stepson.
Read petition, my lord. Not a stepson, my lord.
You should consider.
Yes, biological father. That
human rights.
So
just cannot say.
Yes. So then
like
what had happened? Illegitimate son out of extramarital.
No. Akin to stepson. Or as a son.
No, my lord, the law is clear. Whether
anyway, we'll not go
illegitimate or legitimate biological father means a son only. So, my lord, that what happened pertinently, my lord, this is a case where deputy commissioner issues an impugn order, is additional deputy commissioner, on the basis of my son, on the pretext that there was a complaint, there was an application filed before the customary court for a decision. And in the meantime, additional deputy commissioner issues an order stopping the work going on in that land. And as a father, I have to part my property to the son. Then only he will accrue the right. And this is for the first time I'm coming across that a deputy commissioner, additional deputy commissioner on access the jurisdiction, stalling the public project. This has to be interfered with, or
Mr. Titi Tara, the counsel for the petitioner. Which one? You are one.
Lordship, I'm for respondent number 3. I'm also praying for some time because I wanted to file affidavit petitions.
MS G. R. Basar, the state council. Appearing for respondent number
1 and 2.
1 and 2.
I'm for 3.
And Anju for respondent council for respondent number 3.
Lordship, 3.
Records were called.
Yes.
Records may not actually is not necessary. Only we have to examine the legality and validity of this impugn order passed by the additional deputy commissioner Manchuka, whether he has a power or not to stall the government project in this manner.
The learned counsel for the respondents press for and granted 2 weeks. 3 weeks.
Milord, that will be too much, Milord.
2 weeks.
Once this project, is a time-bound project, Milord.
No, they are asking for a time. They
No,
have
no.
right to
Kindly see 711 order, Milord.
Right to contest.
Yes, 7, that I agreed. They have
As
asked
the
for
matter
2
is
weeks.
The public project, this court is of the view that this matter shall be decided earliest. According listed,
They
Where
have
is
asked-
the impugn order?
Yes, Milord, page 33, Milord.
Who is constructing?
I am constructing, the father.
What is the project?
That is construction of a link road, Milord. Construction of the link road, Milord. Page 33 to 35 is the first impugn order. Then second is at page 36, Milord.
You are private respondent.
Lordship, private respondent.
What benefit you will get if the payment and the work is stalled?
Your Lordship, there's a dispute of land between me and my father, Your Lordship. I'm claiming,
And the dispute cannot be taken up by the additional deputy commissioner.
Lordship, that's
Now,
the,
after the civil courts act.
Lordship,
If
the
it is
part-
pending before the customary court,
Customary court.
one
Lordship,
can think about it. How can he be, how can the additional deputy commissioner can take up?
Lordship,
If there is a law and order problem, only he can interpret.
Lordship, Lordship may,
After a week,
Lordship, at least 2 weeks' time, I'm praying.
No,
for
no,
you
no,
to
early
file
may
your
not.
affidavit, Your
No,
Lordship,
no.
Because
He don't have any case. Private respondent.
have some
2 weeks.
consolation with your learned friend.
I can always do that. What is this?
That's why.
Fifth December.
Huh?
5th December, madam.
That's his. On the prayer of the learned council for the respondents, list this matter
On 5th December, with or without affidavit, Milord. I'll argue on the law point.
on 5/12/2023.
Lordship,
You don't
Enough.
have to file, it's a matter, it's a writ petition or what?
Read petition.
read petition.
Whether he has a jurisdiction to pass this order or not.
Why
that's-
not 22/27?
No, but-
Cesura right? Are you seeking cesura right?
both.
Mandamus cannot.
Lordship, can it be on 13th, Your Lordship? Thursday.
No, my lord, kindly on 5th, Milord.
It's a matter of 1 week. What?
There is more than 1 week, Milord.
Huh?
More than 1 week. Today is 23rd.
It's okay. You have filed this in the month of September only.
No, Milord, project is stalled, Milord.
It's
If-
okay. 13, 12. You should have.
13 is which day? No, which day? Wednesday.
Wednesday.
Well, kindly on 12.
At least have.
Otherwise, Milord, the court order was very
No, I
clear.
am also very clear.
Yes,
DC cannot,
DC
ADC
cannot.
cannot.
that is the only question to be adjudicated.
Only, this is the only question. This is the only question.
Yes, affidavit is also not required even.
So on that, you try to
Because
indicate.
they have filed one writ petition which was disposed of, directing the parties to.
That is another thing.
approach the
You can approach,
appropriate forum. That I have approached.
Okay. So.
Matters
that we will not go into,
Related.
Milord. If I go into, I
Appropriate
won't that
forum,
case.
according to it's the additional deputy commissioner.
No, Your Lordship. The matter is pending before.
Village
Village
authority.
GP, Your Lordship.
Problem, difficulty is, if it is pending before the
It's still pending. That has to be.
difficulty is, the gap in the law is the enforcement by the village authority. There is no provision. The legislature need to look into it. That's why they approach the deputy commissioner and additional deputy commissioner. Practically, you have to understand, it may,
No,
you may be
that-
decided tomorrow.
No, but that's section 17 of the 21 Act is very clear. If the lowest customary court is not adjudicating a matter, they can approach this to the district administration court straight.
No.
But this is not the way.
That's why my enforcement, even if the village authority passes some order, enforcement is very different, implementation, execution. So
Execution is
You
DC.
may, remember, you may be that side tomorrow. So it's for all. So according to me, there's a gap in the law.
Causes omissions.
Need to look into by
Causes
the
omissions.
legislation.
Causes omissions is there. Grateful.
All right.
May I please, Lordship? This is a case of maternal death, Your Lordship. It's a case of 2015,
It's become infectious.
not infectious.
Lordship, I'm on behalf of Tita Gum, standing counsel.
It's 2015 matter.
Yes,
When do you want? as a last chance.
last date एक fix कर दो.
Only what you have to show is there is a negligence.
Yes,
If there is a negligence,
there is a complaint.
we may.
Yeah.
But if we find that there is no negligence, no compensation.
Yes.
As a last chance, huh? It's a 2015 matter, and the two compensation. Daughter-in-law died. Is it? He's the father. No, he's we see
His daughter, petitioner is the mother-in-law also.
mother-in-law.
Yes,
Oh,
mother-in-law.
daughter-in-law died. Have you filed the affidavit?
Yes, we have.
Pleadings completed. Madam,
Pleading come.
pleadings are completed.
11th, your lordship.
11, 12.
December.
Ah, okay. Her MS learned counsel for the petitioner and also no, Mr. Arko, learned counsel appearing on behalf of Mr. T. Tagum, learned standing counsel for health department, submits that his senior Mr. T. Tagum has some personal difficulty for which he seeks for 2 weeks time. He seeks for adjournment of the matter for 2 weeks, Mr. Praise the Lord. Mr. List the matter on 11/12/2023, Mr. However it is. Not however, since the matter is of 2015, no further adjournment shall be granted on the prayer of the other parties of the matter. No, it's okay. No further adjournment shall be granted.
Obliged, your lordship.
Obliged.
May I pay your lordship? My lord, here the lane of the petitioner has been acquired for construction of establishment of law college, my lord. And no compensation has been paid.
But you have donated.
No, my lord. That's why, my lord, repeatedly there is a direction from this honorable court. Whether there is any gift deed, whether, but kindly see the, my lord, order dated, my lord, 22/8/2022. They took this contention.
22/8.
Yes, my lord.
26/9 or 22/8?
22/8. And 26/8 also.
2018.
2008 or 2022.
Okay. You said 2008.
And 26/8 also it was.
22/8.
26/8 is, it was directed.
Yes.
On the question of, on a question being put as to under what premises the land of the petitioner was taken away and utilized for construction of law college, and unsubstantiated statement is made, petitioner has donated the land. If it is so, the respondent number 2 also to produce the deed of donation by which the petitioner has donated the land. Right from the beginning, my lord, I have prayed for compensation. I requested the department to pay compensation.
Is it then is under the possession of the government?
Yes, my lord, already constructed law college is functioning. They have forcefully taken over the possession, my lord. I have made a list of dates, my lord.
What do you say? Any documents?
Lordship,
Do you receive any
that is strong
documents?
submission. Lordship may come to annexer 1 itself, Lordship, in the notification, Lordship. In the notification itself, it is mentioned that it is donated, and then Lordship may kindly come to.
Which one?
My-
Your affidavit?
My affidavit, Lordship.
Well, I'll just
By
see.
1, 2, and
Just
6.
wait, huh?
1, 2, and 6. Affidavit by 1, 2, and 6. Page 15.
1, 2, and 6. Huh?
Affidavit by. Page 15, Annexure 1.
Just wait.
Affidavit by 1, 2, and 6. That's it.
Affidavit. Page
Page 15, Lordship.
15. Yes.
Yes, Lordship, in the second
Notification.
notification, Lordship. In 2 itself, Lordship, it is, and whereas Deputy Commissioner UP has filed letter of event number dated so and so, 11th March 2010, informed that the private landowners are willing to donate free of cost the land described in schedule below for establishment of localized JOTE. And whereas the proposal for donation free of cost land of so and so 19.36 acres described in the schedule below has been accepted by Government of Arunachal Pradesh for the purpose of establishment of localized by the Department of Education, COPT of AP. Now, therefore, the said land is hereby notified under Section 10 of the Balipara, Tirap Sadia, so and so, Regulation 1947 for establishment of law college by Department of Higher and Technical Lordship.
Yes,
And
the subject to execution of proper deed of donation and other formalities.
Yes.
Para 5.
In
Where
para
is-
5.
Where is that?
That, Lordship.
That is also within 1 month, my lord.
Just wait.
Yes.
We are
Lordship.
saying that it's your private land, you have not donated,
Yes,
but then you have said something, there was an agreement to give you some benefits.
but nothing has
There
been
was
come
a
out.
promise or something like that.
But
You will be given
I have-
employment or some work, something like that.
The
You
work
have said so.
My initial,
Have you given them a work or employment?
Lordship, we
No.
have annexed the
Power of attorney.
in
What-
from Annexure 2 onwards, Lordship, by way of power of attorney and by way of Lordship, it's stated in the paragraphs also, Lordship.
Where
from
is the power of attorney?
Annexure 2 onwards, Lordship.
Jumla minute solution.
Now, after all this, they come up when they know that we can't vacate the land. Now they come up with this, that we have not given them the compensation. After establishment of the whole law department there, law college there. For this works, Lordship, the power of attorney is also there in Annexure 7, page 37.
Page 60. Have you replied this?
yes, my lord. Even reply is there in the affidavit
Has
itself,
been
my lord.
amicably settled between the parties concerned for which you were voluntarily agreed to withdraw the complaint and assured the implementation agency that we shall not further disturb the smooth function. Are you the petitioner?
Yes.
Nabam Rana.
Nabam Rana.
Huh?
Yes.
What about this
Petitioner number 1.
affidavit? Huh? Imlam Minu and Nabam Rana. Oh, you can approve it and reprove it.
My lord, department itself said, my lord, that we can consider at best 150 rupees, 150 per square meter.
Dismiss.
My lord, how my private land will be forcefully taken away, my lord? They have, their
Why you
contention
have
is that
donated?
They have.
And
no,
you have,
no.
after donation, you have agreed and you have agreed to all and you have made a complaint.
No,
that
my
you
lord,
have not
right
been
from the
given the
my lord,
employment. Just wait.
Yes, my lord.
You have been given, you have not been given the employment, contract work, which they have promised. You have made a complaint.
Yes, my lord.
You withdraw, you said by affidavit.
No, when you
Thereafter,
stop.
thereafter,
No, my lord.
then by filing an affidavit, they said you have settled the matter. And then you come back and say, now before this court saying that no.
That affidavit was made to the extent that that work should be smoothly complete.
Huh.
When we stopped the work,
Huh.
when no compensation was paid.
You have said settle the page
No.
60.
When they have not paid compensation, my
But
lord.
I think you should try before some other bench. This cannot be permitted. See, you just cannot take the advantage of the
No, when we
technicalities of
ask
the
for
law.
contract work, my lord, their statement contention in paragraph 7 is that we cannot go beyond the CPWD manual. You cannot work alone, give you works. Their contention is that now they say.
But admittedly, without apart from the technicalities of executing a deed of donation.
Nothing
right?
is there, my
Right.
lord. We have
Nothing is there. But
insisted.
but the fact remains that you have donated.
No, no, my
You
lord,
have
time is-
donated free of cost. Once you have donated, let's keep aside for a timing. Let's keep aside the technical. So this is something. It's a college. Law
It's a college for the interest of public. We are willing, but we said, let us execute the deed of agreement first. They have not forthcome. They have said notification was issued on, my lord, notification. Very haphazardly they have taken, my lord. Notification was issued on 24/3/2011.
Are you saying
And-
that the state has played a fraud on you?
Yes, my lord. On deputy commissioner on 11/4/2000 within.
Prima
not-
facie, it appears that
before
you are
completing
trying to
1 month,
take
my lord.
undue advantage
My lord, before.
of the technicalities. Of course, they are also not pre. I mean, they should be blamed for that.
No, my lord, right from the beginning, we have complained that adequate compensation may, suitable compensation may be paid to us. We have not said that.
Compensation, not the land compensation. Compensation by way of employment and
Nothing has been
contract work.
Nothing has been forthcoming.
So was it a condition that one, if it doesn't, if the, as promised, but then if these things are not given to you, you will take it back.
No, my lord.
You
that
take
is-
it back in that case.
Yes.
You give it back.
After all the establishment, lordship, in our statement
Doesn't
also, we
matter.
have said that the
For
contract works have
haphazardly,
been
my lord,
given to them.
notification was issued on 24/3/2011. The
For-
land possession was issued in favor of the director within just after 20 days. Whereas there is 1 month time is given for claiming objection. Before completing 1 month, they have issued the land possession certificate in favor of the director.
Because it's well.
And director also requested the
Have
executing
you
authority.
made a complaint to the deputy commissioner?
My lord, we have repeatedly approached
What
to
is
the.
are you challenged that the LPC also?
No,
Are you
my lord,
challenging the
we are-
LPC
we are
also?
just, at this stage, we are paying for an adequate compensation.
No, once the possession is given to them, land possession certificate, it indicates that they are the owner. If it is to be paid, it will pay to the department who is having the land possession
Acquiring
certificate. Is not it? So you have to challenge that
And
basically.
acquiring authority also said, they have stated, my lord, the director informed the principal secretary that the land compensation may be at the rate of, my lord, 150 rupees per square meter.
Where it is said?
It is page, annexure 6, page 21.
21. Principal Secretary.
Yes, Director, Higher Education. Second paragraph, madam. Since NSPC has provided fund for to the PWD for establishment of law college, department may like to consider for payment of compensation at the rate of 150 per square meter as the cost of dry horticultural land to the landowners.
At best, we'll direct them to provide employment or other works, not compensation.
No, if they provide. my lord,
Because
my lord.
reason is very simple.
Yes, my lord.
You
If
are
they-
not challenging the LPC by this writ petition, right?
We want compensation, my
What's-
lord.
no,
We
no.
also said, my lord,
See-
if they
See,
can't.
once you are once you donated the land, the right and ownership goes to that person.
No, if they provide group C and group D posts also, we have said, we have requested to the authority. If they can provide us group D and group C posts, that also suffice. But they
You
say,
claim that.
we have claimed,
Not the compensation of the land.
my lord, we have claimed,
Land is no longer with you. You are not the owner of the land.
we
No.
have claimed, but nothing has been provided.
I understand there is a technical, the procedure has not been followed for donation or whatever
Yes, my lord.
acquisition.
We requested for agreement. First, you execute the agreement with us.
Hmm.
And in lieu of this, my lord, donation of our land, you provide a job, group C or group D. We are not requesting them for provide us a officer post and all.
How many of you?
Two person.
We may direct them to, direct you to consider for providing employment in group D or C.
Group C
C
and
is
D.
lordship now, it comes under,
No, as per their
Yes, ma'am.
education, they will give.
What do you say?
if lordship see my page
Will- will-
6,
will-
enough
will-
work
will-
orders have been given to these two people.
Work orders have been given.
Yes, lordship, come to para 6, my, page 6.
This statement
This
is
is-
on contrary to the statement made in para 7 of their affidavit.
Maybe, but
They
then,
said we cannot go beyond this CPWD manual and the CWC
that's clear,
guidelines.
but then lordship, because they were
How?
donors.
The works we have got through tender process, they said I have given so and
No,
so.
in fact, have you been awarded?
No,
Yes, MS,
the works we got through the tender process, they said we have given. How they will give?
through
works
tender, we have
illegally?
given them, through tender.
They themselves said, we
But
cannot.
one thing, if you have taken the land free of cost, they may not have a right to claim their afterwards, but then property demands that you should give them some benefits because you have taken on the assurance of giving them some benefits. Or
Lordship.
is it your stand that they have been given as assured? As assured?
No. Not that.
We'll
but
take up
then-
next week.
I have
You take instruction.
my para number
Not
three.
Just discuss with your officers that the
Lordship.
court has indicated
My lord, kindly
that we
consider
may
my para
direct
three.
for, giving benefits as assured. Because there's no dispute that land belongs to them.
Yes, that's true.
Compensation,
No, my lord,
I'm not in.
I have stated in para 3 in my pair.
No, that's what I'm saying. See, we are considering that whatever you've been
Yes, my
assured.
lord, I stated.
Just
two-
wait. This court is of the prima facie view that this, whatever have been assured to you,
Yes.
either employment or some contract work. Contract work is, we cannot say anything on it.
No,
But the
Job.
providing of any post, suitable post in the grade of group D, we
C,
may.
group C and D, my lord.
C
I
is,
said, my lord,
C is
it
very difficult.
Please,
I
the-
stated
Group D, we may.
my pair is.
So
very
we'll ask
clear.
them to take instruction.
Yes, my lord.
But though you have not prayed for, you have prayed for only.
Yeah, I have read para 3.
for,
Group C is
employment.
nowadays
Yes,
graduation
okay.
post almost.
Para
We'll think about it.
UDC comes in.
You think about it and you take the instruction, you discuss, not instruction, you discuss with them. We'll dispose of next week.
Yes.
But
My pair,
no land compensation.
I have stated Malad to provide job to the family members of the
It is
petitioner.
already been established. That's why we may explore to direct
Nothing
the
has been provided
state
because-
respondent to provide you the suitable, the group D post. All right.
As-
Are you
according to
happy?
the- as
Will
per-
will you be, will you be happy?
My lord, ultimately, I have to,
Then compensation, I'm not inclined.
if they provide job also, my lord, it will
Because
suffice
it will be
because,
very difficult. You will have to think about the public interest also.
but the way,
Two persons only, no? Two family.
two family only,
Okay.
two
So in
person.
that case, you think about it, because once you have assured, on such assurance only, then the addition senior government,
Also,
on assurance only land was donated. It's not fair if you don't,
Lordship,
so discuss with the concerned authority and apprise them that the indication of this court.
Lordship, I can do
Right.
that. But then in the beginning itself, the Lordship, job was.
I'll hear you.
That was.
If you cannot do it, we'll decide on the merit. All right.
I'm sorry, my lord. My lord, in the court number 2, my lord.
Yes.
There's on item number 10, which was
Yes.
considered by lordship on 17th.
Huh.
And it was the learned PP was directed to submit on parity.
Huh.
My lord, therefore, the learned court has said that if I may make a request before lordship for taking up this matter today.
No, he can take up.
No, my lord, he
He
was
can-
not
he can take
inclined.
up.
He
No
was
issue.
not inclined to take up.
No.
To
He'll take.
make a request before lordship.
No, he'll take up. He'll take up, you make a mention. See, the matter is now, it's a kind of,
28, madam.
not a written jurisdiction.
Yes.
It's a jurisdiction.
Today's 23.
Yes,
No.
You can very well.
Mondays.
There's no bar.
But there was no.
I was
significant-
sitting
The-
in
that
that court. that-
EPPSC matter, my lord, on parity, lordship was.
A personally, I don't would like to. I
My
don't
lord,
want to.
my lord, I'll
I mean,
inform.
out of the record, huh?
My lord, my lord, my
You
lord.
may make a request.
I'll make a request before that.
If it is listed, we will. Had it been listed here, I would not have any problem.
My lord, my lord.
All right.
My lord.
I think you
I'll.
better understand.
I understand. Deeply.
Let it be on 28.
Huh?
28.
29.
29.
It's too early.
29 not fix আছে মোৰ বেলেগ এটা আছে 28 on madam
Is it?
28
Monday na. Monday is Monday. Tuesday.
Tuesday
28 बहुत तकलीफ है देखो 27 is बंद हम कब ऑफिसर को बात करेगा टुडे इज
30 तारीख को 30 को
30 को ना